Well, the first of two trials accusing Frank Stronach of sexual offenses against several women over decades begins today. In Toronto, Stronach faces a dozen charges involving 7 complainants. The allegations relate to incidents spanning the 70s, 80s, and 90s. The billionaire businessman, who is expected to face a separate trial in Newmarket later this year, has denied all allegations against him. Peel Police charged Stronach with 18 offenses involving 13 complainants in 2024, but the case was later split into 2. Well, Stronach initially chose a trial by jury in Toronto, then switched to one with a judge alone. Well, for more on this case, we're joined by criminal defense lawyer Alexander Karapancev. Thank you so much for joining us. Tell us a little bit more about, I guess, the reasoning to split this case into 2. Why was that important?
Thanks for having me, Jamie. Criminal offenses need to generally be tried in the jurisdiction where they are alleged to have occurred. So I suspect the reason why this case was split into 2 was some of the allegations are alleged to have occurred here in Toronto, while some may have been alleged to have occurred in New York region.
In terms of the decision to switch to a judge alone rather than a jury, from your perspective, why do you think that decision was made?
It's a really difficult decision for the defense to make. There are pros and cons with both modalities. With the jury, 12 people need to be convinced of the defendant's guilt, both unanimously and individually. Whereas with a judge, it's a single trier of fact that decides guilt or innocence. Now, there are some benefits that come with having a judge as opposed to a jury, which include the fact that a judge has to provide reasons for their verdict. A judge doesn't simply say guilty or not guilty. They have to explain why they reached their verdict. And if the judge convicts your client, because they have to provide reasons, that may provide a route to appeal that you wouldn't have necessarily with the jury. Additionally, in cases like this that are in the media, there's a lot of public perceptions as it relates to the Me Too movement, as it relates to wealthy men who in the past are alleged to have committed criminal offenses. Part of the calculus may be that with a judge who's trained in the law will be followed, the law will be implemented, and there'll be less of a potential for bias to infect the trial process.
I'm glad you touched upon that, because I wanted to ask you, as a defense lawyer, given the fact that this man's life and his future really could depend if he were to go by a jury. You have a bunch of people with a lot of different opinions, and sometimes those opinions of the case their emotions factor into their decisions. Whereas a judge who's going to be a lot more focused simply based on the facts and the evidence alone, is that more beneficial to a high-profile individual like Mr. Stronach?
Well, different lawyers have different opinions on this issue. I think if we look historically, if we go back to the 90s, it used to be that if you were a successful male accused of these offenses, juries tended to acquit. And I'm looking at the cases of Michael Jackson, for example, of O.J. Simpson south of the border. But it seems to be that since the Me Too movement, we see more and more convictions in jury trials related to high-profile individuals. And we saw that with Mr. Weinstein. We've seen that with high-profile cases in Canada, like Peter Nygard, for example. So a number of defense lawyers do think that sometimes having a judge in these current political and sociological climates can be advantageous to the defense, because you have someone who's going to ensure that they're not going to allow public perceptions to infect their decision-making processes.
Obviously, a lot of the outcome is going to be based on the evidence that is presented and the testimony in this trial. But when you have allegations that go back 30, 40, 50 years, does that make it more difficult for the prosecution to be successful?
I think it's always more difficult where you have historic allegations, and that's because you typically don't have the sort of evidence that you would have with a recent allegation. For example, I doubt that they're going to have any DNA evidence, any forensic evidence to substantiate any of these claims. Furthermore, witnesses that may have been able to provide some circumstantial corroboration that they saw the parties at a certain place might not be around anymore. They might not remember what happened. So I think the prosecution certainly going to have a tougher time proving these cases than they would if they were more recent and the police would have been able to contemporaneously investigate.
Criminal defense lawyer Alexander Karapancev, thank you so much for joining us. Appreciate your perspective.
Thanks for having me, Jamie.